Yes.
Dr. Rejman, could you look please at DHSC 0017884, please? This is a minute from you dated the 30th of November 1992, so it's after the HIV litigation has concluded. The subject matter is Lord Justice Scott's inquiry, so that's, I think, the Arms to Iraq inquiry. But the relevant paragraph is paragraph 5, where you say, you raise a query in paragraph 3 about the process for ministers signing off PII certificates. And then at 5, you say, my interest in this is that in the HIV haemophilia litigation, ministers signed PII certificates and a procedure was developed between DH and Council over what papers should be covered by PII certificates. What's your recollection of the procedure that was developed in the HIV haemophilia litigation?
Well, I have no recollection, but I have been shown another minute in which there were categories of items that might be subject to PII, such as, I can't, I'd have to look at precisely what the details were, but I think about 5 or 6 categories, and there were things like submissions to ministers, and then internal advice prior to those submissions, something about policy. There are about 5, I think it is in one of the documents, I'm not sure which one it was. So therefore, I presume, 30 years on, my assumption is that that is what that relates to, because other than that, I can't imagine what other, because presumably it was while we were discussing with Council how we go about sorting out what should be in PII and what should not be in PII. That's when, that's the only thing I can identify.
So just to break that down a little, and I hope without needing to go to very many documents, the department received advice from Council, from Justin Fenwick, in relation to the categories of PII that could be claimed.
Right. Well, I don't know which way round it happened. It may be that Ron Powell already knew what the categories were, and that Council was just reaffirming them. You see, obviously I knew nothing about PII prior to the HIV litigation, and so it was either Ron Powell or Council, one or other of them, came up with this categorization, and then in essence the idea was that we'd go through all the documents and identify whether any of them fell into those categories. But I must say, as a rejoinder, one of the individual, it wasn't David Burridge and it wasn't me, but somebody else that was involved in trying to sort out PII came up with some bizarre suggestions of what should be covered.
Well, I'm not going to go through the detailed categories themselves. For the benefit of the transcript, the advice from Justin Fenwick is at DHSC 0038699_013, and that's June of 1990, I think. Let me just check. Yeah, June of 1990, and we can hear, no doubt, from Mr. Fenwick in relation to that in due course. In terms of the exercise which you undertook, or you with others undertook, yes, of trying to apply those categories to the documents that had been identified in the process that you've already described, do you recall whether that was a straightforward exercise or one which called for quite difficult exercises of judgment?
Well, from what I can recall, it was not something that took weeks and months, and I'm not sure whether it took 2 or 3 days or whatever. And I think the thing is, you have to recall that both David Burridge and I had actually been through the discovery a number of times, so we already had a reasonable idea of what was in there. And so I think, as ever, you go through these things and you scan them and you say, and I presume we did it there again, you put them into possibles, pile of possibles, and then between us we look through them again and say, yes, this is one that we can put forward, or no, this is one we won't put forward. And as ever, it's never going to be 100%. I'm sure that we must have missed out some that should have been under PII. Obviously, the ones that we submitted to Justin Fenwick, he obviously looked through those, and I presume he must have said to us, no, this one doesn't. PII wouldn't apply to this particular one, and he presumably reduced the numbers.
And then just a couple of specific contemporaneous documents to ask you about. DHSC 0046958_007. Now, this is a minute from you dated the 2nd of March 1990 to Dr. Rubery, MCD. Who was Dr. Rubery?
Well, Dr. Rubery was a senior principal medical officer, and I think this is communicable diseases.
And then the first paragraph reads that Dr. Pickles mentioned to me that at her meeting with you yesterday, you'd expressed some anxieties about the classification of documents that could be discovered in this litigation. And then there's a description in paragraph 3 of the PII process, which I don't think I need to read through. Do you have any recollection now of what anxieties were apparently being expressed by Dr. Rubery?
I haven't at all, and I'm just I read this because you kindly sent this through to us the other day, and I don't know. I mean, say whether her anxieties were that the classification was too broad, that covered too many documents, or whether it didn't cover enough documents. You can't tell from the minute.
And then one other document, please, which is DHSC 0043223. Now, this is a record of a conference with Council on the 18th of May 1990. We can see who's in attendance, and it includes you. And if we go over the page, we can see the initials at the bottom are PGB, so that's presumably Mr. Brand, who, as you've told us, was working with Mr. Powell in the solicitor's office. If we go back to the first page, I just want to see whether you can help us with this. So I'm just going to read the first few lines. Counsel Mr. Andrew Collins opened the conference by saying that we had not yet sorted out the documents on public interest immunity. We must stop destruction on the date the litigation comes on. Hepatitis, virtually nothing. Most of it has already been destructed. What is policy and what is implementation? Difference. The fact that document is submitted to the minister is not per se PII. If in doubt, claim PII. If there is a doubt, take a second opinion. Documents concerned with the source allocation, I think that perhaps is supposed to be resource allocation, is PII, also competing claims of finance. And then if we just go further down, skipping it down a couple of lines, parliamentary questions and advice on the same are PII, suggested approach and replies of PII, the donor leaflet is not PII, dangers of putting off people who should not give transfusions, since policy is wide, extend PII to include concerns on leaflet, background information is there and is PII because it shows how minister made up his mind. On resource implementation side, those were PII. Before decision is made, Mr. Collins will speak to John Laws so as to get a consistent approach on PII. And so that the reference to John Laws is not a mystery, that's a reference to what was known as the Treasury Counsel or Treasury Devil, the government's principal barrister. Now, the first thing I wanted to ask you about there is the advice that's apparently recorded there about taking it might be said, a very wide and inclusive approach to PII. If in doubt, claim PII. Was that the advice that you and Mr. Burridge would then have adhered to in trying to work out what did or didn't fall within PII?
Well, you see, looking at this minute, it doesn't quite fit with the other minutes about what should be in PII from Council and from Justin Fenwick. So, and you'd have to look at the date of this and the date of that.
This is before Justin Fenwick's written advice, the month
Well,
before.
okay, then I think we would have obviously deferred to Justin Fenwick's later advice.
I think, to be fair, if we just go to the relative passage where it says claim, if there, yes, it's about seven lines down. This may read to some as being notes which are made during the course of a conversation which ranges over a number of topics, because if in doubt, claim PII doesn't entirely fit with the next sentence. If there is a doubt, take a second opinion. So if there's a doubt, there are two things to do. And it seems rather odd that you should mention claiming PII first and taking an opinion about whether it's properly claimed or not later. But it may be that that was what the advice was, but it just reads a bit like a stream of consciousness discussion. I don't know if that helps.
If we can then look, Dr. Rejman, at the first part of the note, where it says, we must stop destruction on the date the litigation comes on. Now, stopping destruction might, as a matter of ordinary interpretation, tend to suggest that there had been a process of destruction, presumably of documents, which Council was advising should be stopped on the date the litigation comes on, whatever precisely was meant by that. Are you able to assist us in understanding what was being discussed here? Do you have any recollection now?
I have no recollection. All that I can do is give my view on how I would interpret it. And my interpretation is that various documents were destroyed at various times because they were past their 5-year limit and they were not considered to be worth keeping. Here, what he is doing, I think, is just reminding individuals, although in that list, I'm not sure how many of them needed reminding, that once litigation about a particular topic is live, you have to stop destroying anything that could remotely be considered as being relevant to that litigation.
Because the litigation itself had been live, to use your phrase, since 1988, I think. So it might be difficult to construe. This seems to be looking to the present and future rather than the past. I appreciate it's not your note, Dr. Rejman.
Yes, I think one of the problems is how good is the note of the meeting? That is obviously the question. Because I think there were sort of spelling errors and things like that in it. And is this the final copy of the note? And for whose benefit was it? Because presumably those attending will be aware of what's in it. Or were there at the meeting, so they may well have made their own notes. You see, I don't know, you see, because as you say, litigation had been going on since 1988. So that sentence doesn't really add anything. Whether it's a reminder to people that even today there is a risk that people may be destroying things, so you should make sure when you go back to your branch, remind them not to destroy anything. I don't know, it may be just a reminder, if nothing else.
The phrase hepatitis virtually nothing, most of it has already been destructed. If we leave aside the use of the word destructed and assume that means destroyed. Does that reflect your own recollection, if you have one now, of the volume of documentation in relation to hepatitis?
Well, as I said earlier, I think the reason why hepatitis documents would have been destroyed is because hepatitis was not a live issue. You know, generally, you know, in the department, hepatitis was there, but it wasn't something that people jumped up and down about. Because as far as most people were concerned, the killer from hepatitis had been hepatitis B, which to most intents and purposes had been sorted out, both with the Rosenheim report, which obviously advised about safety in laboratories and in dialysis units, and about not reusing dialysis lines. You know, the whole, I haven't got the Rosenheim report with me, but, you know, but there was a lot of detail in that. So obviously the number of deaths in and illnesses in dialysis unit dropped after the Rosenheim report came out. And also laboratories became aware, and I'm not sure when Howie's report came out, but that probably predated this as well. So I suspect that on that basis, hepatitis documents, unless there was any specific reason to keep them, might well have been destroyed once they reached their 5-year review date. And if people looked at them and they said, well, there's nothing new in here, this is all old hat, bin it. And so that, I think, is why it says that there wasn't much there.
We can take that down, thank you. Just to complete the picture in relation to the issue of PII, I don't think we need to look at the documents just to establish a basic framework in terms of chronology. It was decided that because the relevant documentation straddled more than one political administration, that the PII certificate would be signed by a permanent secretary rather than by a minister. Is that right?
That is correct, yes.
So that was done. There was then, the matter then came before a judge of the High Court, Mr. Justice Rougier, in, I think, around July or thereabouts of 1990. He made his decision as to what documents, on the question of whether documents that were otherwise covered by PII should be disclosed. And then there was an appeal against that decision to the Court of Appeal. Yes. That's all a matter of public record. I'm not going to ask you the detail. The Court of Appeal's judgment was, I think, handed down on the 20th of September 1990. And is this right? The upshot of that judgment was that there were going to be quite a lot of these documents that the court ruled would need to be disclosed.
I think so, right? Yes.
My question then is this. Did that, as far as you can recall, have any impact on the department's approach to settlement of the litigation? Because settlement discussions then took place over the coming months.
Yes, but I think the settlement, well, I think in the Court of Appeal, I think the relevant comment from the judge there was that there was a potentially actionable case. So in his Court of Appeal judgment, he was basically saying that there might be a case. And I think the solicitors on behalf of the haemophiliacs took this as being, oh, well, they may win type of thing. Now, I don't think the department was that convinced, because I think the department was still convinced that if the case came to court, they would win. Whether, in fact, anything else came of that, I'm not really sure. I think the request from Mr. Justice Ognall for the parties to come to some sort of compromise, I think, predated the Court of Appeal judgment. And looking at the first instance when the plaintiffs approached the department about a compromise, I can't remember the exact date, I think that was September, and again before the Court of Judgment, before the Court of Appeal judgment became public. And so I don't think it made any difference.
So if we then come on to the question of the settlement process, what do you recall being the factors which influenced the department to settle the litigation?
Well, I think there was a lot of pressure, obviously, from MPs, and some particular MPs. There was a lot of pressure. If I'm asked frankly, what I think made the biggest difference was Margaret Thatcher's resignation. That is my personal view. I may be completely wrong, but that, I think, was a relevant factor. And
why was that a relevant factor? I appreciate this is your view, but it's your view as someone who worked in the department and was involved in the litigation.
Right, okay. Why I think it is a view is that John Major came in, and as a new Prime Minister, two things. Like everybody else, you want to brush aside everything that is a problem as much as you can. And secondly, if you can do something that makes you look good, do it. That is my political view, if we want to call it that. And, you know, I think what is relevant is that up until the time, I can't remember exactly the date when we were told that the government has decided that there will be a payment scheme, Justin Fenwick and the rest of us were working on the assumption that everything was going ahead with the court case.
Do you recall the change in Secretary of State for Health? And I haven't got the dates at my fingertips, either in relation to that, Dr. Rejman, but there came a point at which William Waldegrave replaced Kenneth Clarke as Secretary of State for Health. Now, I know you've told us you didn't have much by way of direct dealings with ministers that you can recall now, no. But do you recall whether that made any difference in terms of settlement?
I wouldn't have thought so. I would have thought the decision about payment would have been number 10 primarily, and obviously I think William Waldegrave came in when Margaret Thatcher had resigned.
Can I then just ask you, if we just then go back a few months to a document which follows on from Mr. Justice Ognall's observations or invitation to the parties to think about a compromise. And I just want to ask you about that. DHSC 0044287_217. So this is a draft submission. I think we've probably got the final one somewhere, and I don't think, for the purposes of my questions, there's any material difference. But this is July 1990, Mr. Dobson, and it's been addressed both to the private office of the Minister of State for Health and to the private office of the Secretary of State for Health. And again, you're there on the list of individuals to whom this is copied. If we go over the page, please, we can see there the heading, the judge's statement, and this is the reference to a statement provided by Mr. Justice Ognall. Is this right? Privately to the parties, setting out a suggestion that the government, irrespective of negligence, has a moral duty to take into account the circumstances of the plaintiffs. That's the way in which it's put in that third and fourth line there. Do you recall, first of all, Mr. Justice Ognall making that statement?
I think I was in court at the time, but I do not remember.
Can you recall what your reaction or response was? Was there, or that of your colleagues, was there indignation, or what was the response?
Well, I honestly can't recall. I mean, I think people might have, I just don't know, to be honest, because, you know, it's so long ago that if I say anything now, I may be completely wrong.
If we then just look, so that paragraph number 2 talks about the moral duty and a suggestion that the law shouldn't be made a scapegoat for what might be seen as a denial of the plaintiff's just rights. So that's the way in which Mr. Dobson, at least, is characterising Mr. Justice Ognall's intervention. I just want to explore with you a little the response of the department as set out in this document. So if we go to the next page. Paragraph 5 refers to this statement emphasising both the political and financial costs, and there's a reference to Mr Justice Ognall having made it clear his sympathies were with the plaintiffs. And then we see, if you read further down, Dr Rejman reference to public pressure on the government to act. So we can see identified there political, financial pressure. And then if we go over the page to... Sorry, will I find the right page? I think if we go to page 8, paragraph 16. This is the way in which it's being put by the departmental officials. Officials have found it difficult to reach a consensus view on what's a fairly unpalatable set of options. We can look at the options if we need to, Dr Rejman, but my question is going to be more general. Then goes on to talk 4 lines down of the haemophilics having caught the public sympathy. There are grounds for arguing their precise circumstances are unlikely to be repeated in any other group. Ministers will need to judge whether the political costs of maintaining the present line outweigh the risks of setting an expensive precedent if some further easement is offered. So again, we've got the reference there to political and financial consequences. What Mr Justice Ognall had talked about had been a moral case, a moral duty, which I don't think this document helps us in understand whether the department accepted there was a moral duty or moral obligation. Can you recall whether that issue, the moral case for helping those who'd been infected by their NHS treatment, how that was evaluated by the department, rather than the references we see here to political and financial consequences?
Well, I cannot recall exactly what was said, because ultimately, if one is going to push for a moral case, and obviously it's up to ministers, because it is moral equals political. And after all, officials are not political. They are supposed to give advice which is apolitical, which basically is their best advice on the information they have. And obviously they can say, well, look, this is going to be a difficulty, that's going to be a difficulty. If you say this, then this is what the response might be from the public. But they put forward those views, and then ultimately the minister, or ministers in this, well, ultimately the Secretary of State, and ultimately number 10, because like with all these things, there are levels of whose decision counts most. The ultimate decision is number 10. Below that, it's Secretary of State, and then Minister of Health, and then right at the bottom, the Permanent Secretary of Health, PSH. So it's in that context. So I suspect that what Mr. Dobson was saying here is, look, these are all the difficulties. This is what the judge has said. And you've seen that Andrew Collins said that the judge should disqualify himself from having made that statement. Now, that statement officially was not supposed to go public. I can't recall whether it did or at what stage it became public. It may not have become public for some time, but ultimately the judge made a statement. It may well have been that the judge didn't want to be in the situation where he would have to find against the haemophiliacs. That is another interpretation that one could put on it. Now, that may be being very unfair, but nevertheless, I think there are all sorts of possible explanations as to why he said this at that particular time.
I think, is this right then? You're not then in a position to say the extent to which moral considerations weighed in the mind of those who took the ultimate decisions. Is that fair?
Well, they were aware, and I don't think any politician at that time would not have been aware of the plight of the haemophiliacs and the fact that, you know, as we've said before, that they were doubly disadvantaged, that they were born with an inherited disorder whereby they had problems with education, problems with employment, plus the problems initially of having joints that were severely damaged and the risk of bleeding. All of that they had, and now on top of this they had HIV. So, and I think that was repeated time and time and time again, both in the department and by MPs, and ministers were well aware. And I think that at that stage, ministers may have thought that with their original Macfarlane Trust payment scheme, then at least they were showing some response to the moral duty. And then it was a case of how much further you went.
In relation to the settlement discussions and the ultimate settlement, there are vast quantities of documentation. We've provided you with some, but by no means all, of the documents that you were copied in on. If we leave aside completely for the moment, please, the question of what's been referred to as the waiver or undertaking not to sue in relation to hepatitis, so forget that for the moment. What involvement do you recall you having in the process of settlement, and what is your best recollection of what that process was?
Well, looking at the papers, I mean, I have no recollection at all, but looking at the papers, it would appear that my contribution was pretty minimal. I mean, say, I seem to recall that I may have made comments about the medical aspects, you know, for example. Well, I think I commented upon the category G grouping, which to my mind, well, according to the minutes, I felt that that was a group that should not be given any money because they were people that had not had HIV, and their claim was that by virtue of being related to the infected haemophiliac, they should be given some money, and only the ones that were in the litigation in the end received it. And I think I made a comment that in one of these cases, the parents of a infected haemophiliac were claiming, well, what were their chances of getting infected? Very small indeed, I would have thought.
Can we look at one particular minute that you did author in relation to the compromise? DHSC 0046962061. And this may be the document that you were referring to. So it's a minute dated the 12th of November 1990 from you to Mr. Canavan.
Yes.
We can see you say you've read through the suggested compromise, and there are several points that you say I would suggest need amendment. And then I think we can skip over paragraph 3. And in relation to paragraph 4, you raise a question in relation to category G and those who are not currently plaintiffs. Paragraph 5, you set out the view there, if category G is at all accepted, and I think it should not be, then I think these payments should be made only to sexual partners and should specifically exclude all parents, siblings and others. You said several cases where 2 or more individuals are claiming on the back of one infected haemophiliac. Surely this is wrong. In addition, I think category G payments should not be paid to plaintiffs where the infected haemophiliac has died. And in some cases, the surviving spouse has had negative HIV tests several years after his death and would already receive a payment in respect of the deceased. Now, it might be said, Dr. Rejman, that's not really a medical issue that you're expressing an opinion on. You're expressing an opinion on a category of potential beneficiaries who you don't think should be provided with any form of compensation.
Well, yeah, I think there is a medical aspect to this, because the medical aspect to this is what is the risk to the individual of getting infected. Now, I gather the plaintiffs were saying, oh, well, it's not the risk of them getting infected, it's their worry about the potential risk of getting infected. Now, if an individual is not at risk of getting infected, my comments there, which are medical, is that they should not be paid.
And then if we look at paragraph 6, you say this: as regards the infected intimates, it might well be made a condition that there should be some proof required, since, as you know, there is one case where 2 girlfriends are supposed to have been infected in quick succession by one haemophiliac who is now conveniently deceased. There are also 2 cases of supposed in utero infection which have subsequently tested negative and as such should be excluded. And then over the page, before I ask you a question, top of the next page, you say, I'm very unhappy about paragraph 6. What guarantee is there that an individual will not put herself at risk and subsequently become infected and then claim a sum in the future? Among the ISCs, that's individual statements of claim that I've read, there are several cases where wives have put themselves at risk against the express advice of their medical attendants. How would one deal with such individuals? It would be easier to state that there's a cut-off point after which time no additional infected intimates are accepted. Now, looking at what you've said in both paragraph 6 and paragraph 7 of this note, first of all, again, it might be said, Dr. Rejman, these aren't really medical matters. This is you saying or expressing your opinion that there are categories of individuals who should not be compensated. Would you accept that?
Yes.
And do you have any reflection now on the language you have used, the reference to a haemophiliac who is now conveniently deceased, or the reference to a partner who may put themselves at risk?
Well, obviously today, and having read it through, obviously I would use different language, and I think the word conveniently obviously is completely wrong. But I think the general gist, you see, I think the thing is that, sorry, could I see who this minute was copied to?
Yes, of course, Mr. Powell. If we go to the
who
previous
the copy
page,
recipients were?
It's just, so it's addressed to Mr. Canavan and copied to Mr. Powell.
Copy to Mr. Powell. Right. So basically, I presume Mr. Powell sent us the suggested compromise. And judging, I can't remember the date, but I think this is only about 2 days or so after we received the compromise. So not as though this is something that I would have considered over a long period of time. These are initial thoughts about the compromise and whether I have any particular views. And I think the thing is that although we talk about parallel medical and administrative hierarchy, it does not prevent a medic from having a view which is not strictly medical, or it does not stop an administrator making a comment about a medical view. So I think sometimes if you read through the various minutes that I've sent, and I've actually specifically mentioned that in one of the documents, part in my third statement, that, you know, I've commented upon this particular minute, and I've commented upon the medical aspects, and I've also commented about some non-medical aspects. And I think, in a sense, you see, I think that is what was expected, because after all, with this litigation, as with a lot of other work, you have a group of people working together as a team, so to speak, and each person throws in their views. It's up to the others to decide, are those reasonable views or not? But sometimes people come up with views who you would not have expected that very good view to come from them because of their background. I mean, so we had this, you know, we might be discussing something medical and an administrator throws something into the ring and the rest of us think, well, that's a good idea. We're medics and we didn't think of that. And I think that is the reality of how the system operates.
And then I want to ask you about one further paragraph in this document, but in order to do so, I want to go to the proposed heads of compromise that you were commenting on. Yeah. So that's DHSC 0003654_117. if we go to the third page, please, it's paragraph 12, which says the defendants should commit themselves publicly to giving haemophiliacs and their infected intimates the best possible treatment to delay and alleviate the effects of HIV infection. So that was one of the suggested broad grounds of compromise that the plaintiffs' representatives were advancing. Is that correct?
Well, I mean, say my interpretation of that is that the haemophiliacs wanted to be sure that having been paid these sums of money, they were not going to be put on the back burner and that they were going to have less good treatment. And I don't think the government ever thought of doing that. So I think it was an unnecessary comment, but I suspect that somebody, one of the solicitors in the group, decided that they wanted that put in writing.
So that's the suggestion that is made. And then if we look at your comment on it, so if we go back to DHSC 00469662_061, and we go to the second page, we looked previously at paragraph 7. If we look at paragraph 10, we can see here the reference to point 12. So that's why I took you to back to the document from the plaintiffs' representatives. And then you say this, I think this should be resisted fully. Any such statement would suggest that these individuals are not already getting the best possible treatment and might lead to absurd demands for all sorts of fancy drugs to be used, as well as, for instance, giving high purity factor VIII at whatever cost to these haemophiliacs. This really would be committing the department to something totally outside its remit. Now, it might be said you've taken what is a request to get the best possible treatment to delay and alleviate the effects of HIV, and it might be said you've rather mischaracterised it as giving rise to absurd claims for all sorts of fancy drugs. Do you have any comment now as to whether you would
well, I don't
say something
know, you
different
see,
now?
I think one of the points with any minute that I would send is it's sometimes difficult to know whether the minute that I'm sending is after discussion with colleagues or not, and what, you know, so for example, this sort of comment might well have been that I was chatting to John Canavan before I sent him the minute, and in a sense here I'm sort of confirming our discussion, that in a sense one just wants to be careful that any such commitment is not used to try and push for excessive treatment which is not necessary for haemophiliacs and to make them a special case, so to speak. So that is my interpretation.
Again, Dr. Rejman, then just looking at this document as a whole, the passages we've looked at, the reference to excluding category G, the reference to the haemophiliac who's now conveniently deceased, the suggestion that women might put themselves deliberately at risk of HIV infection, and then the reference here to the possibility of absurd demands for all sorts of fancy drugs to be used. Putting those together, it might be said here that you're being rather dismissive of or pejorative about the plight, the situation in which those who've been infected with HIV found themselves.
I don't think so. I think basically this was a compromise. This was the early compromise received from the plaintiff's solicitors. And I think, like with every form of negotiation, you have the two sides coming from extremes. And the final compromise invariably is somewhere in between the two, in the middle. And as I say, I think these comments were literally a day or two after the compromise was shown to me, and I'm not sure how much of what is in that minute had already been discussed with John Canavan, and I'm just putting, you know, on paper what we had discussed. And ultimately, you know, neither John Canavan nor I would be the deciding factor as to what the final outcome of the compromise was going to be. And not even Ron Powell, because ultimately it would be Justin Fenwick acting on behalf of the department that would actually make decisions. And obviously the thing is, any sort of comments like these are people sort of look at them and say, well, that sounds reasonable, or they say, well, that's just rubbish, and just that is it. And the fact that it happens to have been minuted or written down does not make it any more important. If people who are even, for example, if I, on reflection, having read it a few days later, say, oh, well, that doesn't sound sensible, you know, but I'm not going to send another minute to people saying, well, look, I got this wrong, I got that wrong. If I wanted to, I'd probably speak to John Canavan or Ron Powell and say, well, yes, I think that was probably a bit over the top and really, you know, you shouldn't really pay attention to it. But they wouldn't. You know, if it wasn't sensible, then they wouldn't pay attention to it. And I think that is, in a sense, one of the advantages of having a system where you have a number of people involved in decision making. So people at my level making suggestions, some of which are accepted, some of which are said, well, no, that's just not on. And people at various levels, everybody throwing their views in. And then the final upshot, hopefully, is a combination of what is best.
So I note the time. My last topic on the question of the HIV haemophilia litigation is in relation to the waiver, and I don't think that's something which I should try and do very quickly, or that it's fair either to those listening or indeed to Dr. Rejman to do at nearly 4:45. So
no,
perhaps
I
we
think
can pick
that's
that up
better
in
wait
the
till
morning.
tomorrow morning. So we'll take a break at that stage and come back to that issue and further issues, obviously, tomorrow morning starting at 10. So 10 o'clock tomorrow.